Hello, my name is Armando Lopez Aramburu, and I'm majoring in computer science. For this presentation, I'll be talking about data protection around the world, focusing on France, Germany, European countries, and the United States. Let's begin. Let's start off with data protection in France. France handles their data protection is not quite direct. They don't necessarily have a standard explicitly required. However, in their national data protection laws in regards to international transfers, it is considered that there are some transfers that are not allowed. Data protection in France continued. Another aspect in France data protection is that it has a convention that debates over data regulations. The purpose of these conventions is to attempt to strengthen personal information protection guidelines. The personal information data includes healthcare data, credit information, education records. Now let's look at data protection in Germany. Germany has different federal data protection law for the government and private companies, where the transfers carried out and the regulations they go through aren't the same. In the end, Germany prides themselves of having the most intricate legal standards from their European neighbors in regards to how they handle the international data transmissions. Data protection in other European countries. Any nation in the European Union has their businesses protected all personal data, including an individual's cookies and IP addresses. For a company to use such data, all they need to do is have a button on the website that explicitly states that the business will be using their data and give their consent. Data collection/protection continued. Within the European Union, the guidelines they have to follow are A. Process the data fairly and lawfully. B. Collect data only for specified, explicit, and legitimate purposes, not further process it in any manner incompatible with those purposes. C. Collect and store data only to the extent that is adequate, relevant, and excessive in relations to the purposes for which it is collected and further processed. These are the regulations. D. Ensure that all data held is accurate and where necessary kept up to date. E. Not to keep data in a form which permits identification of data subjects for longer than it is necessary for the purposes for which the data was collected or for which it is further processed. Now, before I start going on with more data collection within the European Union, I'd like to talk about what I found along my sources. For my Pensar source titled Data Protection in the United States versus Europe, What Businesses Need to Know, the author talks about how the EU used to work under the Data Protection Directive for their data protection regulations, and with this, it applied to all businesses and sectors. Now, as of May 25, 2018, the General Protection Regulation is the forefront of the data protection laws and regulations in Europe. This new law regulation's main purpose is to take the earlier law, the Data Protection Directive, and take a step further with it for even greater transparency and trust around the individual's protection, privacy, and collection. Later along this article, the author talks about how the United States and their approach to handle data handling and protection is the exact opposite of the European Union citizen-first approach. The only way businesses haven't taken advantage of this is due to federal laws that prevent unfair and deceptive practices in regards to an individual's data protection, privacy, and collection. But the real issue is that the U.S. laws regarding how to handle data and protection of said data are wide-ranged and may differ from state to state, making them more complex and vague to their European Union counterpart. Near the end of the article, the author talks about how the General Data Protection Regulation, or GDPR for short, may go global. The author talks about how there are advantages to the relaxed nature of the United States data storage laws, but ultimately the underlying problem is that consumers tend to not trust companies with their data anymore. Not only do consumers not trust companies, but the vague data laws that businesses have to follow may be accidentally misused, and as a cost, business could be potentially fined. But with the GDPR, it would simplify and clarify the data laws for any business that follows it, and with such clarity, there are hopes that it could go global for the protection of businesses and also enhance the protection of an individual's data. Okay, now let's get back to what's on the PowerPoint. Along with the regulations the companies have to follow, they need to accomplish one of the following for the data processing to be considered legal/lawful. A. The data subject must have given their unambiguous consent. B. The performance of a contract to which a data subject is a party. C. Comply with the law. Data collection within the European Union continued. Along with the following: D. Protect the data subject's vital interest. E. Advance public interest or facilitate the exercise of an official authority. F. Further the data controller or another disclosed party's legitimate interest without infringing the data subject's fundamental rights and freedom. And before we get on to this upcoming PowerPoint slide, I'm going to read off of what I've found on another source. From the IADC source, EU Data Protection and Conflict of Laws, the usual bag of tricks, or fight against the evasion of the law, by the authors Cecilia Lahey and Paul Lefebvre. The authors talk about the GDPR, or the Global Data Protection Regulation, which I have mentioned earlier, and its goal of setting up a digital single market, which grants citizens the highest possible commons standards so that they remain in control of their own personal data. This new regulation will bring back or attempt to mend the consumer to business relations, as well as provide businesses with a clear set of laws they have to follow in the digital economy. The authors state that at the core of the GDPR lies the rule, one continent, one law. What does this mean for businesses or companies outside of the European Union? Simply, they also have to apply by the same rules when they are offering services in the EU, but with the simplicity of the GDPR, the process will run a lot smoother and be cost effective. Actual processor of the personal data will become directly liable for compliance with some parts of the regulation in which the processor or control can be identified on the basis of the following questions. 1. Does this entity devote substantial resources, example, staff, financial means, to data protection compliance? 2. Does it determine the corporation's policies on data use within the Union, ensuring the new products are compliant with European Union legislations? 3. Does it decide on the withdrawal of certain products should they appear not to meet with the European Union requirements? 4. Does this entity decide on a third party to be given access to the personal data that it holds and under what conditions? 5. Is there a contractual relationship between this entity and the data subject, allowing for the data subject to make inquiries about their data before this entity, or possibly lodge claims and complaints about this entity? 6. Is this entity the focal point with regard to law enforcement and police investigations regarding personal data? 7. Does this engage with the local data protection control agency in order to ensure its compliance with both local as well as European Union data protection legislation? Towards the conclusion of the article, the authors state that the main purpose of the GDPR from the European Union is to ensure a universal set of laws that all businesses within the European Union borders in regards to data protection/security have to follow. With this, it will clear all sorts of misinterpreted data laws and also offer the highest level of protection of European citizens' personal data. Now let's talk about the challenges for the United States. The U.S. has a group known as Personally Identifiable Information, or PII for short, which is data they deem needed to be protected. Such data include are the following: names, addresses, telephone numbers, and anything else that is deemed for marketing purposes has a different form of privacy. Or conclusion. Relative businesses that want to do trade within foreign countries have to meet the standards and protect data protection for both sides. One may argue that it takes more time out of the business aspect, but in reality the majority are similar to one another. And if the GDPR goes global, it will harmonize both sides of the foreign countries and make trade a lot faster and easier along the way. As you can see, here are the 4 reference materials I used in regards to gathering information on the data laws, regulations found in France, Germany, the United States, and European countries. Yeah, have a good day.